This is a video about the causes of action, Replevin, and Detinue. At times, you might need to stop the video, replay it, and take notes to understand the subject. Please pause the video to get something to write with before proceeding. Someone has your property. You asked for it back. They will not return it. There are two causes of action that may help you. A cause of action is the legal claim you bring to court. This video explains both. But first, answer 3 questions. If you answer yes to any of them, this video will not help you. I will tell you where to go instead. Question 1. Did a government take your property because you owed money to that government? A fine is money you owe for breaking a rule. Parking tickets are fines. Red light camera tickets are fines. If the city towed your car because you did not pay your tickets, the city is holding your car over a fine. A tax is money you owe on income, on sales, or on property. If the state took equipment from your business because you did not pay sales tax, that is a tax. An assessment is a charge a local government puts on you for work it did. A village might build a new sewer line on your block and charge each home for its share. If you did not pay that charge, the village can go to court. The sheriff can then take something you own to cover the debt. A riding mower, a work trailer, a car. If any of these happened, Replevin and Detinue are not the right causes of action. You must deal with the government office that is holding the property. Question 2. Did the police take your property? Maybe they took it when they arrested you. Maybe they took it with a search warrant. If the police have your property, Replevin and Detinue are not the right causes of action. Filing either one will cost you money and it will not work. When the police take property, the state may try to keep it for good. That is called forfeiture. Forfeiture is a different cause of action. It is not Replevin and it is not Detinue. If your criminal case is over and nobody filed a forfeiture action, you ask for your property back in the criminal case. Same courtroom, same case number. If that request is denied, forfeiture matters are heard in the Chancery Division of the Circuit Court of Cook County. If a state agency has your property, a different court may be the only court that can help you. It is called the Court of Claims. If the police took your property, talk to a lawyer before you file anything. Question 3. Has another judge already ordered this property turned over to someone else? Sometimes 2 people claim the same thing. If a judge already ruled on it, you must tell the court about that ruling. If you answered yes to any of those 3 questions, get advice before you do anything else. You can call Carpels at 312-738-9200. A lawyer will talk to you. There is no charge. Carpels also has a help desk you can join online, weekdays from 9 in the morning to 4 in the afternoon. You can join by video. You can also join by phone. Dial 312-626-6799. Then enter the meeting ID. It is 477-826-7667. Make sure the person giving you advice is a lawyer. Now, the 2 causes of action. The first is called Replevin. You use Replevin when the other person still has your property and you want the property itself back. The second is called Detinue. You use Detinue when the property may be gone. With Detinue, you ask for the property or for its value if it cannot be found. Here's the difference in one sentence. Replevin gets the thing. Detinue can get the thing or money in its place. Most of this video is about Replevin because most people want the thing. What you must show for Replevin. 5 things. 1. The property is something you can point to and describe, not money someone owes you, a thing. 2. You own it or you have the right to hold it right now. 3. The other person has it right now. 4. You asked for it back and they said no. 5. Your right to hold the property is stronger than their right. Now, let me explain 3 of these because people get them wrong. Regarding number 4, ask for the property back before you file. Ask in writing. Send a text or an email or a letter and keep a copy. That copy is your proof. There is one exception. If the other person has already made clear that they will never return it, You do not have to ask again. But if you are not sure, ask in writing anyway. It costs you nothing. Regarding number 3, the other person must still have the property when you file. If they sold it, gave it away, or threw it out, Replevin will not work. There is nothing for the sheriff to pick up. That is when you think about Detinue instead. I will come back to that. Regarding number 5, this is the heart of the case. The judge is not asking who behaved better. The judge is asking one question. Who has the stronger right to hold this property right now? You must prove that your right is stronger. Equal is not enough. If the two rights are equal, the other person keeps the property. And this surprises people, so listen closely. It does not matter who is at fault. It does not matter who was unkind. Those things may matter very much to you. They do not answer the judge's question. Bring proof of your right to the property, a receipt, a title, a photograph, a message where the other person admits the property is yours. What goes in the complaint? The document you file with the court to begin legal proceedings is called the complaint. For Replevin, there is a form. Your complaint must say 6 things. 1. A description of the property. Be specific. A brown chair is not specific. A glass table is not specific. The dog is not specific. Give the brand, give the model, give the color and the size, give the serial number if the item has one. If it is a dog, give the breed, the name, the color, and the microchip number. A sheriff should be able to walk into a room and know which item is yours. 2. That you own the property or have the right to hold it now. 3. That the other person is wrongly keeping it. 4. That the property was not taken over for a tax, an assessment, or a fine. That it was not taken by the police or under any court order against you. And that no judge has already ordered it turned over to someone else. Those are the 3 questions from the start of this video. This is where they appear on the form. Do not skip past this part. 5. The value of the property. Stop here, because people get this wrong. The value line asks what the property itself is worth. What would it cost to replace it? That is the number. It is not asking what this whole situation has cost you. It is not asking about your time, your stress, or your trouble. Just the property. 6. Your signature. When you sign, you are stating that everything in the complaint is true. There are penalties for signing something false. One more thing about that value number, and it is important. Before the sheriff can go get your property, you must give the sheriff a bond. A bond is money held as a promise. The amount is double the value of the property. So if you say the property is worth $100, the bond is $200. Know that cost before you start. And know this too. Filing the case does not return your property. The judge holds a hearing. At that hearing, you must show 2 things: that your right to the property is stronger than the other person's, and that you are likely to win in the end. Only then does the judge sign an order. When the property is gone. Now, detinue. You use detinue when the property may no longer exist or when nobody can find it. With detinue, you ask for the property, and if it cannot be found, you ask for its value instead. What you must show is close to what you show in Replevin, that the property is a specific thing, that you own it or have the right to hold it, that the other person took it or kept it, that you asked for it back, that your right is stronger, so keeping it from you is wrong. But here is something you need to know before you go to the courthouse. There is no form complaint for detinue. You write the complaint yourself from a blank page. That is hard to do alone. If your property is gone and you are thinking about detinue, this is the moment to get help, or you can research how to properly draft a civil complaint. Here is where to get that help. Call Carpels at 312-738-9200. A lawyer will talk to you and there is no charge. You can also join the Carpals Help Desk online, weekdays from 9 in the morning to 4 in the afternoon. Join by video or join by phone. Dial 312-626-6799. Then enter the meeting ID. It is 477-826-7667. If you hire a lawyer, ask whether that lawyer has handled a Replevin case before. Many have not. It is a fair question. Ask it. You can also read more on your own at illinoislegalaid.org. It explains court steps in plain language, and it has forms. This video gives general information. It is not advice about your case. A judge cannot give you legal advice, and I am not giving you any legal advice either.